case. Applications and appeal in the matter of Lufthansa Technik AG, a company incorporated in Germany, and Astronics Advanced Electronic Systems and others.
Yes.
Please, your lordships. I appear together with Dr. Barron on behalf of the appellants Astronics, and Mr. Cuddigan and Mr. Hall are the respondent. As your lordships will have gathered, this is my appeal against the judgment and consequential order of Mr. Justice Morgan. Can I start by identifying what the issues are for the appeal?
Do we need to start with the applications? In other words, maybe you were coming to that, so I'm jumping in too early.
Yeah.
The application to re-amend the grounds.
Yes, I've discussed with my learned friend the overall route map.
Right.
I'm going to come to claim 3, which is the subject matter of the most recent application to amend after I've dealt with the other issues. So it's going to come at the tail end of my submission.
Right, because we have to decide whether or not to give you permission to re-amend your grounds.
You do, absolutely right. But of course,
might it not be helpful to deal with that at the beginning?
My lord, we could. I think it's more logical to fit it in at the end when we've done the other claims. Your lordship is content with that.
Is that right? Yes. Okay.
Of course, the other procedural matter is that, as I'll be elaborating, I do need permission to appeal in respect of anticipation of claim 1 over Neunschwander.
Well, that was just adjourned to be listed.
Correct. That's right.
Can you remind me? Was it with appeal to follow if granted, or what was it? How was it?
It was simply the order was simply made that the application for permission be adjourned to your lordships.
Right.
So your lordships will have to decide whether I can have permission to appeal.
Yes.
On Neunschwander against claim 1 anticipation.
Yes.
And with your lordship's permission, I was proposing to make my submissions on that once we get to Neunschwander, and
yes.
your lordships understand what the issue is, rather than
yes. I mean, I think it would be appropriate to treat it as appeal to follow.
Yes.
Because we can't separate it out.
No.
Yeah.
And also, the issues are as follows. There are 2 issues of construction in relation to claim 1 of the patent in suit, that is, inserted and remotely. And if the judge was wrong as to construction of inserted, and also wrong as to the construction of remoteness, I say that claim 1 is anticipated by Neunschwander, and that's the subject matter of what we've just been talking about there. If the judge was wrong as to the construction of inserted, but right as to the construction of remoteness, I say that claim 1 is insufficient for conceptual uncertainty, as are claims 2 and 3. Alternatively, claim 1 is obvious over Neunschwander. As far as claim 2 is concerned, if claim 1 is anticipated or obvious over Neunschwander, then your lordships will have to consider whether claim 2 is nevertheless obvious. And then finally, claim 3, if claim 1 is anticipated or obvious over Neunschwander, as your lordships know, I'll be inviting you to find that claim 3 is obvious, but that's the subject of my most recent application. So in terms of route map, subject to your lordships, what I propose to do is to take the issues in the following order. First of all, to provide an overview of the patent in suit, and if at any stage during the course of that exercise I'm going too slowly, then by all means chiver me along, but it may speed things up to go through the specification in a little bit of detail right at the outset. Then a very brief look at the law. I'll then deal with construction, then insufficiency, then anticipation of claim 1, obviousness of claim 1, obviousness of claim 2, and then claim 3. So could I start with the patent in suit, which is in the supplementary bundle number 1, and it's behind tab 1. And can we start with the claims, and just identifying the claims, the key relevant components. So I'm on page 7, which I think is electronic page 10. I don't know if your lordships are working with electronic bundles or hard copy bundles.
Firstly, I think there's a combination.
A combination. All right.
So
I'll have to say both every time, I'm afraid. So electronic page 10, hard copy page 7. And your lordship see within claim 1, the subject matter of claim 1 is a voltage supply apparatus for, in other words, that is to say, suitable for, providing a supply voltage for electrical devices in an aeroplane cabin. So supply voltage could be a high voltage, for example, 240 volts AC. And electrical devices in this context includes items such as laptops. Now the pre-characterizing portion, that is to say up to line 19, introduces a number of components and describes how they interrelate, including a socket, see that in line 5, first mentioned in line 5, a plug, line 6, and in line 11, a so-called supply device. Now in line 8, the socket is said to include a detector for detecting the presence of a plug inserted in the socket. It's called a socket detector in line 8, but its function is to detect the presence of a plug, and it's referred to elsewhere in the claim as such, as a plug detector. There is also a signal line between the socket and the supply device, see that's at line 13. And line 15 provides that the supply device applies the supply voltage to the socket when the plug detectors indicate the presence of the plug via the signal line. So that's the pre-characterizing portion, and then the characterizing portion, the plug detector detects the presence of 2 contact pins of the plug in the socket, and the supply voltage is only applied to the socket if the presence of both pins is detected simultaneously. So the 2 issues of construction, first in line 3, socket or plug detector detecting the presence of plug inserted in the socket. Judge held that that would be understood to mean fully inserted into the socket, that is to say with detectors at the bottom of the holes which receive the pins of the plug, and that partial insertion on the judge's construction would not be enough. And then the second issue of construction, line 11, the supply device is provided remotely from the socket. The judge held that would be understood to mean more than separate, and it requires the supply device to be arranged in such a way, the judge's interpretation, that there is no source of danger to the passenger. Now, as the judge rightly held, paragraph 216 of the judgment, claim 1 deals with the so-called single knitting needle problem. And that is a reference to the risk of electrocution if a single conductor, for example a knitting needle, is pushed into the live term. And that risk is, and was at the priority date, addressed in conventional domestic sockets with shutters that cover the live and neutral apertures and which are opened by insertion of the earth pin. The way in which the invention of the Claim 1 solves or deals with that problem is providing, as it does in the characterizing portion, that the supply device only applies the supply voltage if 2 contact pins are detected simultaneously. Now, Claim 1 doesn't, as the judge rightly held, solve the so-called double knitting needle problem, that is to say, the insertion of metal objects into both apertures. That problem is, and was at the priority date, ameliorated in certain types of domestic socket, for example shaver points, with a shutter system that only opens when pressure is applied to both live and neutral apertures. That wasn't a complete solution to the double knitting needle problem, but it lessened the risk of electrocution because it requires appropriate pressure to be applied to both apertures at the same time. Claim 2 does address the government's unusual problem. And the way it does that is by timing the detection of the first and the second contact pins. And the supply voltage is only applied to the socket if a maximum time between the two detections is not exceeded. The other problem just to mention in the context of airline seat sockets is one which is referred to in the judgment by the parties as the drenching problem. That is to say, liquid, whether from a spilt drink or a liquid cleaning product, enters the socket and causes a short circuit or possibly an electrocution. And the judge held correctly that Claim 1 deals with the drenching problem. So those are the problems to identify right at the outset. Since we have the claims in front of us, I'll just very, very briefly show you the subsidiary claims. Claim 3 deals with a device in which the plug detectors comprise mechanical switches. Claims 4 to 6 are concerned with a feature which we are going to look at in a moment, concerned with a casing detector, and claim 7 is concerned with the central voltage source, which we don't need to look at. So those are the claims. As far as the specification is concerned, can I pick it up at hard copy page 2, electronic page 5? We have paragraph 1, which is describing invention in very general terms. There's more specificity in paragraph 2, which explains that passengers with a power supply for electrical equipment need a supply for devices such as laptops and so on via seat sockets. Paragraph 3 introduces 2 particular safety aspects which need to be taken into account. One is passenger safety, and the other is interference with the aircraft systems. There are references in paragraphs 3 and 4 to 2 existing systems. The first provides low voltage DC into the sockets. The second supplies mains voltage but requires a key switch. Paragraph 5 introduces an item of prior art called quintel, on which the introductory clause of Claim 1 is said to be based. 6 identifies the task, in other words, the object of the invention, which is increased safety against incorrect application of the supply voltage to the socket, said to be solved in paragraph 7 by the features of Claim 1. And then looking at the paragraphs that follow on, the pre-characterizing features of Claim 1 are addressed in paragraphs 8 to 10, and the characterizing features of Claim 1 in paragraphs 11 to 12. And then over the page, paragraphs 13 to 18 concern various preferred embodiments, and they track the subsidiary claims. Paragraph 19 through to paragraph 47, that is to say the end of the description, explain the details of one embodiment of the invention, accompanied by figures 1 to 5. And actually, as it happens, that embodiment embodies all of claims 1 to 7. Can I now just briefly show you the figures? So figure 1, page 9, electronic page 12, is clearly an airline seat inside. Now the cable that runs at floor level is labelled 28 and 29. That's carrying mains voltage, and it's connected to the supply device, which is component 16, positioned below the seat. The socket is labelled 22, and the dotted lines between the socket and the supply device represent the signal line, that's number 18, and the line for the supply voltage, which is 20. Figure 2 is a view from above. You can see the laptop plugged into the socket. And then over the page, so page 10, electronic page 13, shows some of the components and circuitry of the supply device 16. So that's the large rectangular block, just slightly to the left. The socket, labelled, identified as 22, and the plug 51. Now, in the socket, there are two plug detectors. They are the micro switches 45 and 46 at the bottom of each plug hole. They are activated by the ends of the plug contact pins. Those ends are identified as 56 and 57. Now the micro switches, that is to say 45 and 46, are connected to the supply device by signal lines, both labelled 18. And this embodiment includes a third signal line, which is identified as 18 prime, which is fed by an optical reflection sensor in the socket, that sensor being labelled 48. And the sensor comprises an infrared emitter and a receiver diode, and is triggered when the distance between the plug casing and the socket falls below a minimum distance. The three signal lines, 18 and 18 prime, feed into what is called a control and monitoring unit, that's labelled 60 inside the supply device. And the control and monitoring unit switches the mains voltage onto the supply cables, which you can see coming down from component 60 labelled 20 triple prime. And they feed the socket via two components. First of those is item 64, and that is what is called a line monitoring detector, and one of its functions is to prevent the introduction of electromagnetic interference from the consumer device, like the laptop, for example, into the aeroplane's onboard electrical system. The other component through which the supply voltage passes is a short circuit detector, that's component 62, and that prevents the supply device being overloaded, and it also switches off the mains voltage if there's an electrical fault caused by the consumer device, the laptop in other words, or tampering with the socket. And then lastly on this page, figure 4 shows the socket that we're looking at in figure 3 but face on. You can see the optical reflection sensor 48 in the middle, and two pairs of plug holes, rectangular and circular, at right angles to each other. And then over the page, page 11E14, that is dealing with the subject matter of claim 7, which is the central voltage unit. Well, that's a brief overview of the patent. I was then going to turn to the law, and I was going to take your lordships to the judgment, which is in Core Bundle tab 9. I would ask you to turn to page 97, so that's Electronic 108. And I was going to pick it up at paragraph 65. Where the judge explains that there are many judicial statements of high authority as to the correct approach in relation to claim construction, and he refers to paragraph 5 of Lord Justice Jacobs' judgment in Virgin Atlantic and premium for the proposition that claims would be construed purposively. Elsewhere in the judgment, I have in mind, in particular paragraph 78, although it's in a different context, the judge refers again to Virgin Atlantic, that decision of the Court of Appeal, albeit in that context for the purposes of acknowledged prior art. But the judge does not, in his account of the law, refer to what Lord Justice Jacob held in Virgin Atlantic and Premium concerning the role of reference numerals in the claims in relation to claim construction. And could I ask your Lordships to take the authorities bundle and turn to tab 2. I think it's sufficient if I ask your Lordships to turn to what I have as page 15. I'm afraid I don't know what it is in the electronic bundles, but it is paragraph 16 of the judgment. So I'm in Virgin Atlantic, paragraph 16, which is at least hard copy, page 15 of the bundle.
Yes.
And could I ask your Lordships to read to yourselves paragraph 16 and paragraph 17? So reference numerals do have a very limited role. They help the skilled person to get the general notion of what the patent is about, but they play no role in relation to construction at all. Put the authorities bundle away and return to the judge's account of the law, and just to complete what he said in paragraph 65. The judge goes on in paragraph 65 to remind himself that there is no rule that claims must be construed precisely to match the embodiments in the description. Claims may be narrower than or wider than those of the embodiments, which is absolutely correct. Now, that is all I wanted to say about the law for purposes. Can I then turn to the first issue of construction, inserted? And as I've indicated, the judge held that detecting the presence of the plug inserted with socket means, or would be understood to mean, fully inserted. I'm going to take your Lordships to the judge's reasoning, but so you know in advance, my criticisms of my respectful criticisms of the judgment are that the judge construed that term using the reference numerals and the specific embodiment to limit its scope. And in place of purposive construction, the judge undertook essentially a linguistic analysis of the specification. So if we can pick it up in the judgment on the same page, page 97, Electronic 108, the judge considers this first construction issue, as I say, inserted, starting at paragraph 67 and his analysis runs through to paragraph 79. But it's paragraph 69 to 75 that contain the critical reasoning. Paragraphs 76 to 79 are relevant to one aspect of the respondent's notice, which is intel. So could I begin by looking at what the judge's starting point was? And it's in paragraph 69. And as the judge says, he's going to start with the wording of the claim. And there are two aspects of the judge's reasoning in this paragraph. The natural reading as deduced from figure 3, and what he calls the natural reading as deduced from the use of past participle. But let's deal with the first of those. In paragraph 69, he identifies the relevant wording as the presence of a plug inserted in the socket. You can see that in the fourth line of that paragraph. And the judge's first port of call is not to ask what inserted in the socket would be understood to mean as a matter of ordinary language. Instead, he begins by considering what is detecting the presence of the plug, that is to say, the socket detector, and that this element is identified in the claim as including that which is numbered 45 and 46. You see that in the sentence that bridges page 97 and 98. And just pausing there, if one turns to the claim, apologies for jumping backwards and forward in the specification. We were looking at the claim right at the outset. So page 7, electronic 10 of the patent. At line 7, that's what the judge is considering. And in fact, there are not 2, but 3 references against the socket detector. 45, 46, and 48. And we're going to come back to that in a moment. But just to make a note at this stage, the judge has pulled out, for the purposes of this part of the analysis, just 2 of them. Now, the judge is here focusing only on the microswitches 45 and 46. And he says, simply to understand what is referred to in the claim, it's necessary to refer to the drawings. He refers to figure 3, and he says that it shows the detectors numbered 45 and 46 at the bottom of the holes which receive the pins, as indeed they do. And we're going to see later on in the judge's analysis that his characterization of the arrangement in figure 3, that is to say, detectors at the bottom of the holes, features large in much of his subsequent reasoning. I'll come to that, but at the moment I'm just looking at where the judge started. Now having referred to figure 3, having observed that they are shown in figure 3 as detectors 45 and 46 at the bottom of the holes, the judge goes on to refer to the fact that the claim requires those plug detectors to be formed so as to detect the presence of 2 contact pins. He gives those contact pins the relevant numbers. And then he says the natural reading of claim 1 is that it is describing detection which occurs when the contact pins make contact with the detectors at 45 and 46. And all that is how the judge construes claim 1. Pins that make contact with the detectors at 45 and 46, because his conclusion, which one sees in paragraph 75, is reflected in essentially the same terms. His conclusion is, based on the above considerations, I conclude that Claim 1 requires the insertion of a plug in a socket to such an extent that the tips of the pins of the socket make contact with the plug detectors at 45 and 46. Now, paragraph 69, as I said a moment ago, deals with two things. The first is the judge arriving at the natural reading of Claim 1 being that it describes detectors 45 and 46, those detectors at the bottom of the hole, at the bottom of the pinhole. And then in the last sentence of paragraph 69, the judge says that in addition, the natural meaning of the words inserted in the socket using the past participle suggests that the plug has been fully inserted rather than partially inserted, although that might not have been the only possible reading if there were other words, if there were other wording to contradict that natural meaning. Now, of course, if one has already determined, as did the judge, that the natural reading of the claim is that it is describing detection which occurs when the contact pins make contact with the detectors 45 and 46, and therefore upon full insertion, then the use of the past participle is plainly consistent with full insertion. But in my respectful submission, I don't accept, as a matter of ordinary language, that the past participle means full insertion unless there are words to contradict that meaning. And that is why context and purpose matter.
But are you complaining with the fact that he's taken into account the fact that the contact points are at the very end, i.e. 45 and 46? Or is this some more subtle complaint that they're also numbered and that's he shouldn't have taken, so to speak, he shouldn't have been guided to that by the numbers? I mean, we all know what Zodiac, Virgin Atlantic decided. Mm-hmm. But I mean, you've got to, the court there said it's entirely permissible to look at the diagrams and indeed the numbers are part of it to understand what you're actually dealing with.
Absolutely.
Now, once you've done that, once you've got into your head that that's actually how the thing works, that's how it's set out, that's how it works, mm-hmm. You then go back to the language of the claim and decide what's covered.
Yeah.
But I don't at the moment see what's wrong with having regard to what you know about how the thing operates in trying to give meaning to the language. I mean, surely that must be permissible.
There is, I think, my lord, the key distinction here is plainly one is entitled to look at the figures, one is entitled to look at the reference numerals in order to get a sense of what the invention is about. And one is plainly entitled to look at figure 3 and say, well, I can see in figure 3 that in that figure, that is how the system is set up. But figure 3 is only an embodiment.
Yes, no.
Figure 3 is only an example of the invention. And my criticism of the judge is that he's arrived at really right at the outset by deciding that the natural meaning of the claim is what he says here.
So you say it's the wrong way around. You should have gone, what, to the language?
It would have been permissible to go to the language and seek to understand what the language would be understood to mean in the context of the purpose and what is said in the rest of the specification. But what the judge has done here, in my respectful submission, is go straight to the reference numerals and the positions at the end. That's what he says in 69, and that's what he ends up with in 75.
Mr. Apple, what I'm struggling with, which may be the same thing that my lord was asking you, is what difference it would have made if the reference numerals weren't there. As I read the paragraph, what the judge was doing was looking at and seeing how that worked. And of course, naturally, he used the reference numerals to refer to what he was looking at. But it's not obvious to me that the reference numerals themselves have got any significance. What the judge was doing, which, speaking for myself, he was entitled to do, I would have thought. That's a different question from whether he did things in the right order, which is part of the point you're making. What's wrong with saying, I need to understand how what these words mean, and I need to look at the picture in order to understand what's in the picture? That's legitimate, isn't it?
It's completely legitimate to look at a specific embodiment and to say it's relevant to see how that particular embodiment is operating.
Yeah.
What is not permissible, and indeed, insofar as the judge is simply using the numbers as shorthand, he's using the numbers as shorthand for the specific embodiment. Now, what the judge should have done, and my submission hasn't done, is to say, well, that's just an example.
Right.
I've got to stand back and make sure that I'm not construing this claim solely by reference to the specific embodiment, and that's fundamentally where the error comes in.
Okay.
But to be absolutely clear, I have no objection to the judge referring to the figures. That would be absurd to suggest that.
Are you almost submitting that he's using that as determinative of the meaning of Claim 1?
He is, absolutely. That's why I place such reliance upon his conclusion in paragraph 75. Because having 75 not only replicates where the judge starts, but it shows where he ends up.
Sorry,
he ends up with the plug detectors at 45 and 46.
Yes. Sorry, that was 70, 75. Yes.
Did I say 75?
Yes, you did. You did.
Yeah. 75. Lords, I was just embarking on a submission as to the importance of context and purpose. And as for context, we shall see in the specification that it makes clear in my submission elsewhere that full insertion is not required. And as for purpose, Lords, the purpose of the invention is plainly to increase passenger safety. The invention of Claim 1 requires an assessment of whether two contact pins of the plug are simultaneously present in the socket. And as explained in paragraph 12, if that be the case, it can be assumed with a high degree of probability that a plug, rather than some other instrument, has actually been plugged in. That purpose is achieved whether the detection is carried out during or at the end of the travel of the plug pins. Now, with that start, can I now turn to the judge's reasoning that follows in paragraph 70 through to paragraph 74. Now, in paragraph 70, the judge is addressing here what the patentee refers to as the casing detector. And in paragraph 70, the judge considers this issue in the context of the claims, although the submissions to him were in fact based upon the teaching in the body of the specification. And can I show you the relevant teaching in the body? So I'm back into the patent in suit. And could I ask your lordships to turn to page 3, which is electronic safety. So paragraph 13 deals with claim 2, paragraph 14 deals with claim 3. Paragraph 15 is the first of 3 paragraphs concerning the casing detector. And paragraph 15, as it says, preferably the plug, I think that must mean the socket, comprises a casing detector detecting the presence of the plug casing of the plug at the socket. Only if the plug casing is close enough, i.e. brought closer than a predefined distance to the socket, is the plugged-in plug casing detected. This provides an alternative or additional criterion for detection of the plug at the socket. And then paragraph 16 explains that the casing detector is an optical reflection sensor and detects a minimum distance from the plug casing to the socket. And paragraph 17 is preferably a disclosure of having both the casing detector and the pin detectors. The importance, my submissions, I attach particular importance to paragraph 15 and the disclosure of the plug of the casing detector as being an alternative means for detection of the plug at the socket. Now turning to the judgment, so paragraph 70. As I say, the judge is dealing with this point in the context of the claims rather than the specification. But about 2/3 of the way through that paragraph, he finds correctly, in my submission, that the patent refers to 2 different methods of detection of a plug in the socket. And he then refers to claim 1 as requiring detectors at the bottom of the holes. Note again the judge's reference to what he sees disclosed in figure 3. And he says that the additional detection process in claim 5 does not detract from the clear requirements of claim 1. But my lord, the criticism that I would, respectful criticism I would make of the judge in relation to paragraph 70, is having found correctly that the patent refers to 2 different methods of detecting a plug in the socket. In circumstances where one of those methods does not require full insertion, that was plainly a relevant matter. Or to put it in this way, the judge has indicated at the end of paragraph 69 that the natural meaning of the words inserted in the socket using the past participle suggests that the plug has been fully inserted, although that sense might not have been the only possible reading if there were other wording to contradict the natural meaning. And all the disclosure in paragraph 15 does contradict that reading, because it's a disclosure of a casing detector which does not necessarily require full insertion of the plug in order to operate.
Is there an importance about the difference between additional and alternative methods? What I'm getting at is that the judge identifies that the patent refers to 2 different methods, and you've explained that you agree with that bit of the judgment there, and then says that he doesn't. The last sentence refers to it as additional.
Yes.
But I think in your submissions you were referring it to as alternative. And
yes.
I can see that what I'm troubled about is that claim 1
yes.
is a claim to a pin detector,
yes.
not a casing detector. So a casing detector is not another way of being a pin detector. It's a different additional detector.
Absolutely right. The point
It sounded like you were suggesting something different, and that's why I'm asking the question.
in that case, I wasn't being sufficiently precise. I apologise. As far as the claims are concerned, when one looks at the claim dependencies, then the claim dependencies work in such a way that I think it is an additional method. And so I don't criticise the judge's analysis of the claim dependencies. My criticism of the judge is that he has overlooked disclosure in paragraph 15, which is not necessarily something that is claimed, but is part of the overall teaching of the specification, in which the casing detector is taught as an alternative. And because it's taught as an alternative, although not later claimed in the same way, that is a relevant item of disclosure when it comes to understanding what insertion must mean.
Okay, but that's what I was confused about, because it's not just the dependency of the claims, that the hierarchy of the way they're written, which gives you that conclusion. The claim that we're construing is a pin detector. And a casing detector is a different thing from a pin detector. It's not an alternative pin detector, it's an alternative to being a pin detector. It's a casing detector. So I don't understand, that's why I'm confused by the point you're making.
Paragraph 15.
What is it that has been overlooked?
Paragraph 15, or rather, let's take the judge's finding first of all in paragraph 17. The patent refers to two different methods of detection of a plug in the socket. Now, I accept that.
Okay.
I have no quarrel with that at all. So, one of the methods of detection of a plug in the socket is to use the casing detector. Now, that is a different method for detecting the plug in the socket. It is disclosed in paragraph 15 as being a means of detection, an additional alternative criteria for detecting of the plug at the socket. Now, if it is an alternative method of detecting a plug in the socket, and that method does not require full insertion of the pins, then that is material which is inconsistent with full insertion of the pins being the only circumstance in which this invention can be said to work.
Does the casing detector require any insertion of the pins?
Yes, well, it certainly would require some insertion of the pins, as disclosed in the specific embodiment, because it's on the front of the socket.
Yes, I just wonder whether there would be a point reached where it would be sufficiently proximate to the socket to enable the casing detector to operate regardless of whether the pins had actually entered into the socket.
Well, we don't have any disclosure of the minimum distance.
No, I'm not asking you to get the evidence. I'm just wondering whether what one gets out of the language of 15 and the disclosure of 15 in terms of informing the construction of Claim 1. I mean, the judge to some extent helps you, but I'm just not quite clear whether what he says is obvious or necessary. Anyway, it doesn't matter.
Well, I think going back to paragraph 15, combined with the judge's finding, I think the language of 15 does help, because what the patentee is here talking about are methods 4, quite clear from paragraph criteria for detecting whether there is a plug at the socket, put it that way.
Yeah, no, I understand.
Are you connecting this with the reference in Claim 1 to 45, 46 and 48? Because you pointed that, or is that not part of your submission?
No, it's to be clear, it's not part of my submission in this sense. That when one looks at the claim dependencies, it is described in Claim 1 as being a socket detector, but then the claim, by way of the characterising portion, limits itself to
Yes.
only certain types
Yes.
of
Yes.
pin detectors.
Yep. Thank you.
Lord, I was then going to move on to paragraph 71. So we looked at paragraph 70, which is the plug casing. Paragraph 71 is one in which the judge refers to numerous references to the plug being plugged in or inserted. And he says, again, the natural meaning of these words is that the plug is fully plugged in or inserted. I've already addressed your lordship on the inserted. As far as plugged in, actually, let's just continue, just so your lordships have all of paragraph 71, and you have my submissions on it. He refers to the natural meaning of plugged in or inserted, and then he says, more relevantly, the description explains the way in which the detectors 45 and 46, referred to in Claim 1, work. These detectors are at the bottom of each plug hole, and he refers to other paragraphs concerned with the specific embodiment. So, three submissions on paragraph 71. First and foremost, we see the judge resorting again to the reference numerals and the specific embodiment as being of particular relevance. He says, more relevantly, the description explains. Second, the specification does include a number of references to plugged in, but not in the claims, which refer to the application of the supply voltage when the presence of the plug is detected. And the third submission is that the term plugged in is used in different senses in the specification. And let me give you the clearest examples of those that I can. Your lordships could take the patent again and turn to page 2, E5. And take, for example, paragraph 2, the sentence which starts at line 11. For this purpose, in the interior of the aeroplane cabin, sockets are located primarily in the area of a passenger seat or group of seats, in which the plug of the electrical device is plugged in so that the device can be connected to supply voltage which can be applied to the plug. Plugged in paragraph 2, I think I would struggle to suggest that wasn't connoting something that was fully plugged in. By contrast, could you turn again to paragraph 15? This was the discussion about the casing detector. Second sentence of paragraph 15. Only if the plug casing is close enough, i.e. brought closer than a predefined distance to the socket, is the plugged-in plug casing detected. So there you have an example. The judge says plugged in is used consistently in the specification and always means. I'm paraphrasing the judgment, but he treats the word plugged in as necessarily meaning plugged all the way home. And there is an example of plugged in being used quite clearly to suggest a degree of insertion which is not necessarily all the way home. So that's the judge's reasoning in paragraph 71. And then the fourth topic, or third topic in relation to insertion is paragraph 72, and this is the figure 4 point. And the judge's reasoning in relation to figure 4 runs all the way through to paragraph 74. Now, we looked at figure 4 very briefly in my opening overview of the specification. Could we just look at it again and pick up on the text that accompanies it? So the figure was on page 10, electronic 13. And figure 4 is the socket that is shown in side view in figure 3, face on. And one can see that from the use of the same numerals, and it is also described in paragraph 24. Description of paragraph 19, which is a description of the figures. The top view of the face of the socket. Now, turning to paragraph 32, which is on page 4, electronic 7. Patten is explaining that figure 4 shows the insertion sign for rounds number 22. And there are European plug holes and there are American plug holes. And the European plug holes can be supplied with a different voltage to those of the American voltage. You see that at column 7, at line 12. It goes on in that paragraph to explain that instead of the European and US plug holes being at right angles, which is what one sees in figure 4, they can overlay each other. And just so your lordships have a sense of what that actually entails, if I could ask you to take the supplementary bundle 1 and turn to tab 17, which is page 296, electronic page 299. This is a schematic representation of what is envisaged by that disclosure at the end of paragraph 32, which I put to Professor Wheeler and with which he agreed. You can see the American receptacles, are they horizontal or are they circular? I'm not sure which the American. I'm not sure which the American, which the European. European is round. So the European round and the American on the inside. So that's the overall. That's the idea of what is being disclosed there in terms of overlays. And the patentee explains that in those circumstances, where they're not at right angles to each other, but rather overlay each other, the microswitches are arranged to the sides of the plug holes. Now, turning to the judgment, just two preliminary observations, looking at paragraphs 72 to 74. The judge appears to downgrade this disclosure as he refers to it as a possibility throughout 72 to 74. And he places weight on the fact that there is no drawing no illustration of the position of microswitches. They're said to be to the side, but are not shown in any drawing. But the key reasoning is what he says in paragraph 74. In paragraph 74, he says, Claim 1 requires microswitches Yes, that's right. So at the beginning of 74, Claim 1 requires, apparently expressly in Claim 1, that the plug is detected when the pins make contact with microswitches at the bottom of the plug holes. See again that reference to the judge's characterisation of figure 3. He accepts that the disclosure in paragraph 32 is part of the material to be considered. But he says that the wording of Claim 1, with its express references to the drawings, and I emphasise that, requires a full insertion. That is how it should be construed, and on that basis, he says at the end of 74, neither Claim 1 nor any other claim expressly deals with the arrangement in paragraph 32. Now, the criticism that we make of the judge there is that, as we've said in our skeleton, in effect he's putting the answer before the question. The question is, the fundamental question is, how should one interpret, or how would the term inserted be understood by a skilled person? And to say that, I think as the judge does, which is, I've already decided that Claim 1 clearly means full insertion. Therefore, when I look in, or when I see a reference to the switches being at the side of the sockets, I can discount that because I've already decided that inserted means fully inserted. Another way of putting the submission to your lordships is that the judge has identified at the end of paragraph 69 that the natural meaning should be given to inserted as being full insertion, unless there are words that contradict it. There is a clear disclosure, there is an express disclosure in the specification of microswitches at the bottom of the plug holes. That is in the context of figure 3. There is also a clear, express disclosure of the switches being at the sides of the plug holes. And in those circumstances, that is material which the judge should have recognised, pointed firmly away from his interpretation as full insertion. Well, those are my submissions on insertion and where the judge went wrong. Could I just very briefly pick up on a number of points which my learned friends made? And the first is that, well, paragraph 32 is all well and good, the way I put it to your lordships, but it wasn't the subject of any technical evidence. Now, that is correct, although it is notable that Lufthansa, in their skeleton argument, paragraph 23, accept that European plugs and US plugs have different lengths. If European plugs and US plugs have different lengths, then one can immediately understand why switches, which are in the type of configuration where they sit between the American and the US, quite sensibly be arranged to the side in the end. Second point they make is that the evidence that was given by Mr. Borowski, who was my expert, they say was entirely inconsistent with the submissions that I'm putting to your lordships. And could I ask you to take the supplementary bundle and turn to tab 8. And it is page 156 in the hard copy, electronic 159. And at paragraph 130, Mr. Borowski refers to one of the post-characterising features of the claim. And he says in 131, the skilled person would understand that the problem being addressed by the patent is to avoid power being supplied to the socket unless a plug is properly inserted and will be understood and would understand this integer in that context. My Lord, one only has to read on from paragraph 131 to see what the expert is concerned about. And he's explaining that the socket is designed to detect the presence of pins of a plug rather than knitting needles and so on and so forth. So the fact that the witness is referring to proper insertion in my submission doesn't begin to establish that is the witness saying, I understand this to mean full insertion. Two other points finally on insertion. One is quintel. Now, your lordships will, I hope, recall or appreciate that the quintel is the prior art that's acknowledged in paragraph 5 of the specification on which the pre-characterised portion is said to be based. And if you take the judgment, Mr. Justice Morgan's judgment of paragraph 79, this paragraph 79 follows a reference to authorities on which I relied for the proposition that there is no principle of law which requires a finding that the skilled addressee of the patent would obtain and consider full patent specification in quintel when construing the patent. And the particular point that neither Professor Wheeler nor Mr. Borowski gave evidence that the skilled person would do that. But in paragraph 79, he goes on to explain that if the issue is insertion, and that is the conundrum with which the skilled addressee is wrestling, then there's nothing in paragraph 5 of the specification that would lead him to believe that going to quintel would assist. And so in relation to quintel, I respectfully endorse and rely upon the judge's reasoning in paragraph 79. And then finally, as far as the German court is concerned, if your lordships would take bundle SB3. So this is a decision of the German courts in relation to the corresponding patent, or the same patent but the German equivalent. SB3 tab 26. So that's starts at page 760, which must be electronic 763. your lordships turn to page 771, which is 781, and you'll see...
Sadly, Mr. Rackland, adding 3 doesn't work when you get that.
Oh, doesn't it?
But don't worry.
Does it not?
So more insertions later. Internal page 12.
Well, it's okay. Internal page 12. Oh, shall I give up then? It's not going to work, is it?
Don't worry.
I'm sorry. It's internal page 12. Let's work off that. Internal page 12, top of the page, paragraph 2. The court starts with an assessment of who the skilled person is. And the court starts by concluding that the skilled person is actually someone different to the skilled person as found by Mr. Justice Morgan. It's 781. So Mr. Justice Morgan held that the skilled addressee of the patent in suit was, to put it simply, an aviation specialist rather than simply an electrical engineer without any existing knowledge or practice in relation to the aviation field. So they start with a different person. And on internal page 14, E783, they are starting with an assessment of what Quintel discloses. And at the top of the page, only when the plug housing has been properly pressed, in the sense of being correctly or completely inserted in the switch, due to the magnetic field of the permanent magnet, and therefore the signal for switching has been sent to the power. So they're looking at Quintel. They start with Quintel, and they make findings as to what Quintel actually discloses. Then they go to the patent in suit, which is on the same page. And if you turn to internal page 15, first paragraph, with this understanding, detection of an inserted plug according to N31, so that's one of the integers of the claim, presupposes that the plug with its contact pins is inserted almost completely into the holes of the receptacle. This interpretation finds additional support for the description of the apparatus according to the patent claim 1, where it's repeatedly and consistently requires that the plug must be and have been inserted. And in the last bit of reasoning, you will find on internal page 17, just pick it up at the very last line of the preceding page, page 16. In the European examination proceedings, the device according to NIA 14, that's Quintel, was found to be the most proximate prior art. Accordingly, the object, according to the patent in suit, has been made more specific to the extent that a voltage supply apparatus, which will ensure a greater safety against faulty switching of the supply voltage to the receptacle, is to be created. In light of the arguments presented above regarding the correct understanding of the patent, claim 1, the Senate is convinced that the objective goal of the patent in suit has thus been attained. So there are various things that are going on in this analysis. First and foremost, they start with Quintel, and amongst other things, look to see the extent to which the objective problem which the patentee presents over Quintel constitutes an improved safety margin than was found in the prior art. Now, plainly, your lordships, this court it not only is entitled, but should pay great respect to decisions of foreign courts in relation to the same patent. But my lord, where the approach to construction in those foreign courts is different to the approach to construction that is taken in this jurisdiction, then that respect needs to be tempered very significantly. I mean, as it happens, the court, the German court, found that Claim 1 was invalid. Found that Claim 1 was invalid by virtue of the law of that jurisdiction allowing documents to be mosaicked. And I wouldn't get very far in this court if I was suggesting that that was somehow relevant to what your lordships would be doing here. So what happens in other courts in relation to the same patent? It can be of assistance, but is of limited assistance when the approach that is taken to an issue is so fundamentally different.
The law on construction of patents under the European Patent Convention, which applies just as much in Germany as here, is meant to be the same, isn't it? Whether in fact the courts have done it the same way, the law that we're meant to be applying is the same as the law in Germany, isn't it?
It is, my lord.
Okay.
I'm not suggesting for a moment you're not replying.
I thought you were, that's all.
No, I was not saying that at all. I was submitting the process by which construction is arrived at is different. And therefore, the fact that the courts in this jurisdiction have arrived at the same endpoint doesn't follow that your lordship should be taking that same approach here, because the law on construction follows different principles in seeking to resolve ultimately the interpretation of the specification. Well, that deals with insertion, subject to anything your lordship wish to ask me. I was then going to move on to remoteness. And the claim requires the supply device to be provided remotely from the socket. If your lordships take the judgment, paragraph 80. So this is page 100. I think it's correct, so it's E111. Paragraph 80 records the parties' respective submissions. Astronics' submission that it means physically separate. Lufthansa's submission to the judge that it means a sufficient separation as between socket and supply for there to be a material effect on the proximity of that supply to the passenger. Now, the judge didn't accept ultimately either of those interpretations. The interpretation he arrived at is the one that's recorded in paragraph 88, which happens to be closer to Lufthansa's interpretation than mine, but is nevertheless not the same. He says remotely in claim 1 means more than separate, requires the supply device to be kept away from the socket, and in particular arranged in such a way that there is no source of danger to the passenger. Now that language that the judge has adopted there comes from the first half of paragraph 10 of the specification, which we'll look at in a moment. But before we do that, make this observation, that on this occasion, unlike the judge's approach in relation to inserted, the judge did make explicit findings as to the purpose to be achieved by his construction of remotely. And his findings in that respect are recorded in paragraph 94. This is in the context of insufficiency, but nevertheless contains the judge's findings as to the purpose of the remoteness feature. And looking at paragraph 94, one can see that the judge regarded the supply device itself, not the socket, the supply device, as a source of danger to the passenger. And his reasoning was that since the passenger has access to the socket, the consequence of keeping the supply device away from the socket is that the supply device is kept away from the passenger. And therefore, if something happens to the supply device, it won't cause a problem for the passenger. We say, my lords, that the judge has simply lost sight of the language of the claim at this point. Claim refers to the supply device being provided remotely from the socket. not remotely from the passenger. Indeed, there's no mention of the passenger anywhere in the claims. But it's more fundamental than that. The judge talks about, in this paragraph, a risk of something happening to the supply device which could cause a problem such as a short circuit or an electric shock being administered to the passenger. Why, I asked rhetorically, did the judge think that keeping the supply device away from the passenger would lessen the chance of something happening, be that a short circuit or an electric shock? Let's deal first of all with the short circuit. Now, the patent, as I showed you in my overview, does talk about short circuits. Paragraph 30 discusses a component of the supply device which constitutes a short circuit detector. Paragraph 30 of the specification is where that is discussed. And its function, as described in paragraph 30, that is to say the function of the short circuit detector, is, amongst other things, to switch off the power in the event of a fault caused by the electrical device or tampering. And just pausing there, the patentee refers to tampering on numerous occasions. Wherever there is a reference to tampering, it is clear that the patentee is talking about tampering with the socket. The references to tampering in paragraphs 9, 10, 13, 14 and 17. So as far as short circuits are concerned, well, there is discussion in the specification as to short circuits. But that short circuits, the risk of short circuiting, has but nothing to do with any kind of distance between the passenger and the supply device. What then about electric shock? Well, the supply device delivers mains voltage to the socket. One of the features of the invention is that the supply voltage is only supplied to the socket if the plug is detected. And so one could imagine that if the supply device were to malfunction and supply mains voltage continuously, that would create a risk to the passenger, that risk being the receipt of an electric shock from the socket. But that risk is not ameliorated by moving the supply device further away from the passenger. So what is one left with? On what basis did the judge see the supply device itself as a source of danger? There is nothing in my submission in the specification about the supply device being a source of danger. And there is nothing in the common general knowledge, as found by the judge, about the supply device being a source of danger. Let me amplify on those 2 points, if I may. As far as the specification is concerned, paragraph 21, which is the first paragraph in which figures 1 and 2 are described, explains at line 26 that the supply device and the socket are each housed in their own casing. And there was some evidence that was given by both experts that might be said to be relevant to this. Professor Wheeler, who was Lufthansa's witness, agreed that the casing would need to be robust, and if it was in a position where liquid could get in, it would be designed so that liquid could not do so. And as far as Mr. Borowski was concerned, it was suggested to him that the supply device could be exposed. that is to say, uncased. And the witness said that switching arrangement would never be installed without a housing, and even my learned friend Mr. Cuddigan had to accept that to install an exposed device might be an artificial and unhelpful example. Now, we've given you those transcript references in our first skeleton at paragraph 54 and reply skeleton at paragraph 19. And then, so that's what the specification says about housing the supply device. And I've already indicated that the patentee does refer to tampering on numerous occasions. In all cases, he or she is referring to tampering with the socket. There's no suggestion of tampering with the supply device. So that's the specification. What about the common general knowledge? If your lordships turn to judgment, at paragraph 81. Paragraph 81 is recording some submissions that were made by Lufthansa in relation to the construction that we're looking for Moylan. And 81 little Roman 4 is a statement. Professor Wheeler said that it was common general knowledge that it would be necessary to design an ISPSS, so that's an in-seat system, in a way which avoided the safety risk which would arise if the supply device was drenched as a result of, for example, a passenger spilling a drink into the socket. Now we're going to look at the evidence that was cited in that context. But in fact, the judge has not actually correctly characterised the submission that was made to him. Professor Wheeler did not suggest that it was common general knowledge that it would be necessary to design an ISPSS in a way which avoided safety risk which would rise if the supply device was drenched. His evidence was that it was necessary to avoid drenching of the socket. And indeed, as we shall see, that is indeed what the judge found to be the common general knowledge. You then turn on, we'll come back to that evidence given by Mr. Wheeler in a moment. If you turn on, please, to paragraph 90, and just to get the context of paragraph 90, this is where the judge has by now decided how remotely should be interpreted. He gets there in paragraph 88. And then in paragraph 90, he says, I do not need to decide at this stage whether it was common general knowledge that a designer of an ISPSS would need to avoid the risk of drenching of the supply device, and which therefore needed to be kept away from the passenger. Somewhat strikingly, the patent referred to the risks to be guarded against, it didn't refer to drenching. However, I will later refer to certain documents which are revealing us the common general knowledge around the priority date, and they do refer to the risk arising from the socket being drenched. So the distinction here is between drenching of the supply device and a threat to electrocution from the socket caused by drenching. And if we turn on to the judge's findings as the common general knowledge in that respect, it is paragraph 209. Under the heading, the safety problems. This is where the judge is making findings as to the common general knowledge. And in 209 little 2, 209 little 1 is referring to the single knitting needle problem. 210 is the double knitting needle problem. 209 little 2 is the drenching problem. And there you can see in terms the risk of liquid entering the socket, causing a short circuit or possibly electric shock to the passenger. Liquid might come from a spilled drink or from a cleaning product. This was referred to as the drenching problem. So the judge can't have been thinking about drenching of the supply device. What else could he have had in mind? What other form of interference might the judge have in mind? Well, can I ask you, Lordships, if you're on page 125 of the judgment, see what the judge says in relation to something called the ARINC specification. Now, just to explain what the... Did your Lordship see that at paragraph 207 and 208? Just to explain the ARINC specification. ARINC is an acronym for Aeronautical Radio Incorporated. It's an organisation that publishes standards relating to the installation and wiring of electrical equipment on aeroplanes. And the particular ARINC specification that the judge is referring to here, that was published in December 1996, that is to say, about 6 months before the priority date, and it relates to in-flight entertainment system. There's no dispute, there was no dispute between the experts that in-flight entertainment systems were common general knowledge, at least those which consisted of a screen on the back of the seat of the passenger in front of one for watching movies and the like. And the ARINC specification is a document which, as the judge explains, was one which Mr. Borowski had not referred to, but nevertheless was one on which I cross-examined Professor Wheeler. And he says in paragraph 207, he gives an account of what the ARINC specification describes. And just to be clear, about 4 or 5 lines down that paragraph, he says, in particular, it dealt with an in-flight entertainment system and seat controls. It described a seat electronics box and a seat actuator controller. So that's a controller for controlling the passenger's seat position. The seat electronic box was to be placed under the seat and installed so that liquids could not come into contact with the electrical parts. The seat actuator controller was to be installed under the seat area. All components were to be installed so that they could not be damaged and no liquids could come into contact with the electrical parts. As to power, all units associated with the interfaces were to be at 115 volts AC, 400 Hz, and control functions used 28 volts. The judge finds in 208 that Professor Wheeler accepted his skilled person would be able to obtain the ARINC specification, but didn't think that the designer would need it. Mr. Borowski didn't give evidence about the ARINC specification. The judge says, I don't think I need to make a specific finding as to whether the skilled person whom I've identified in this case would specifically obtain a copy of the ARINC specification. I consider that the ARINC specification would tell the type of skilled person, would not tell that type of skilled person anything particularly unusual. It establishes the desirability of placing an electronics box out of the way under the seat, but that is apparently for reasons of cabin design and convenience. It also establishes the need to avoid liquids coming into contact with the electrical supply, but that should have been obvious. Now, those findings that the judge makes in paragraph 208 are significant in this respect, that what the judge did was to reject a submission that I made to him, that the need to install the seat electronics box and the like under the seat was something that was done and would be understood to be done for the purposes of safety. What he finds instead is that what the ARINC specification establishes is that which wouldn't be unusual to the skilled person, which is the desirability of placing that box out of the way under the seat, but that is simply for reasons of cabin design and convenience. Now, Lord, I've already made the observation that the specification doesn't support the judge's interpretation that the remoteness between the supply device and the socket would be understood to be remoteness between the supply device and the passenger. Can I now turn to what the specification does say? Because it does have a paragraph, paragraph 10, which is specifically concerned with remoteness. So just to get our bearings, so it's the specification, column 2, as I said earlier, paragraph 8. Well, I did say this. Paragraph 8 introduces the 3 principal elements of the pre-characterizing portion. The socket has a detector that detects the presence of a plug, and the supply device is located away from the socket and connected to via a signal line to a power cable and a power cable. And then second, the supply device switches the supply voltage. Paragraph 9 explains the consequence, or a consequence, that there's no supply voltage in the socket when it's not being used. And also addresses the hazards resulting from children tampering with the socket using paper clips, knitting needles, and so on. Patent then turns in paragraph 10 to explain the reason for locating the supply device, which may be carrying mains voltage, separately and remotely from the socket. And the patentee says the supply device can then be arranged so that there is no source of danger for the passenger. And that is where the judge stopped. He regarded the supply device as the source of danger, and therefore needed to be kept away from the passenger. But let's read on in paragraph 10, because what the remainder of paragraph 10 makes clear is that the source of danger referred to here is not the supply device, but the supply cables running between the supply device and the socket. So when the socket is not being used, there's only a small signal voltage between the supply device and the socket, but no supply voltage. Now, if the purpose is to ensure that the high voltage cables between the supply device and the socket are quiescent, benign, when the socket is not being used, that purpose is achieved regardless of the distance between the supply device and the socket. And what paragraph 10 is getting at, my lords, is very simple, and it's firmly grounded in the common general knowledge, in particular the common general knowledge concerning the drenching problem, and secondly, the evidence that was before the judge. As far as the common general knowledge is concerned, I have already shown you the judge's finding in paragraph 209, little 2, as to the drenching of the socket being a particular problem. As far as the evidence is concerned, could I ask your lordships to take bundle SB1, and turn to tab 6. And this is the first expert report of Professor Wheeler. And could I ask you to turn to page 68? Internal page 23. And in paragraph 110, the expert is explaining particular concerns that would arise in an aeroplane cabin. And he says at 110 little 2 the close proximity of the passenger to the socket, the fact that the passenger has their meals and drinks near the socket, and the fact that an aircraft can be seemingly unstable at times of flight, all mean that there's a very high risk of severe spillage. For example, an entire beverage pouring into the socket, essentially drenching the socket and leading to electric shock risks. In the same report, if you could then turn on, please, to page 90, which is the internal page 45. And in paragraph 205, Professor Wheeler is considering paragraphs 8 to 10. And he says, paragraphs 8 to 10 explain that the supply device is located separately and remotely from the socket. He goes on to explain it's connected to the socket via a signal line and a power cable. Under normal conditions, only the signal line is connected. Small signal voltage between the signal lines, power cable is not connected, there's no high voltage at the socket. The socket has a detector. The plug is detected, the signal is sent by the signal lines. Patten notes that this combination protects the risks posed by, for example, the knitting needle problem, because when there is no plug, there is no power at the socket, and therefore no risk of electrocution. And then importantly, my lords, in the last sentence, although the patent does not say so, the skilled person would understand that the physical separation of the socket from the voltage supply device also offers some protection against the liquid spillage problem. And that makes perfect sense.
Just explain why.
Because if the supply device were within the socket, then liquid pouring into the socket would create a risk of electrocution under all circumstances.
Oh, I see. Yes, because the supply to the supply device is in the socket.
Well, one's actually talking about the supply to the supply device. There is a supply device, and then the supply device has cables which naturally have live ends.
But the point is, if you don't separate the socket and the supply device,
Yes.
you don't separate them, so they're not separated.
So they're not separated.
The problem then is that the electrical power to the supply device is in the socket.
Correct.
And that's the problem, the drenching problem. Then
That's right. Because the supply device is itself always live.
Yes. Yeah, I see.
So that's why the separation achieves that. And Professor Wheeler went further in his second report, which is behind the next tab. So this is tab 7 of SB. And if you turn to paragraph 41, so internal page 9. Now, the witness is here talking about Quintel. He says the skilled person would recognise that the remoteness feature of Quintel will be useful in the context of SPSS to address the drenching problem as discussed in paragraph 110.2. In this regard, I've been shown a presentation Kid System gave to WAEA Technical Committee in June 2000. Tests involved submerging the outlet unit, whereas the socket, in a saltwater solution, which has a higher conductivity than fresh water, to ensure safety is maintained when the socket is drenched. My understanding that the drenching was a genuine concern amongst those involved in the design of ISPSS, and the existence and characteristics for this test support this view. Can I then summarise, in the light of everything that I've said so far, what my key submissions are in relation to remoteness? Remote would not be understood to be the vehicle for putting distance between the passenger and the supply device. There's no basis for that in the claim the description or the common general knowledge. Paragraph 6 of the specification explains that the object of the invention is to enhance safety against incorrect application of the supply voltage to the socket. And it talks about tampering with the socket. A skilled person knows, as part of his common general knowledge, that if liquid, for example, a spilt drink, gets into the socket, that will also be a problem. One aspect of the patentee's solution is to have a detector in the socket which provides that power is not supplied to the socket unless specific criteria are satisfied. Another aspect of the invention, albeit in the pre-characterizing portion of the claim, is that the supply device is provided remotely from the socket. Remotely, in my respectful submission, cannot be understood as remotely in the sense of far away or at some distance from the socket, because distance is going to make no difference. But remote in the sense of being kept away from or separate from the socket makes absolute sense for reasons which are firmly grounded in the common general knowledge concerning the drenching problem and the evidence that was before the judge. With that, can I now turn to the judge's analysis in paragraphs 83 to 88? And in between paragraph 83 and the judge's conclusion, 88, the judge undertakes essentially an exercise which I describe as one of linguistics. An exercise of linguistics which does not have regard to any purpose that can be ascertained from the specification or the common general knowledge. And your lordships will read for yourselves what the judge says there. But it is fair, I think it is a fair characterisation of the judge's approach to describe it as a linguistic exercise. Perhaps the clearest example of that being where the judge refers to the fact in paragraphs 85 and 86 that paragraph 10 uses language separate and remote. He says, well, as a matter of linguistics, separate, because it's being described as and remote, they must mean different things, and therefore as a matter of grammar, remote can't mean just separate. Now, as a matter of pure linguistic analysis, that is a legitimate exercise. But as a matter of purposive interpretation as to what remote would be understood to mean in the context of a technical document, given what it expressly talks about in paragraph 10, given the common general knowledge, my submission is that simply to talk about linguistics and to approach the exercise as a matter of linguistics is not an appropriate approach to take. And there are examples, my lord, where words that can be used to mean the same thing. I said to your lordship, you're looking very fit and healthy today? It's the same thing. I said, I'm shocked and surprised by that submission, Mr. Ackland. They are simply examples of where it is sometimes the case that two words are used to mean the same thing. So my criticism of the judge in this part of on this part of the appeal is that he interrogated the specification as a matter of linguistics, having started off fundamentally with no proper regard to having misunderstood what the purpose, the underlying purpose was in the first place. Can I deal very briefly with just a couple of points which were raised by the learned friends? What they point to, amongst other things, this is in their skeleton paragraph 51, is the cables that supply device. So we have the supply device, we have the socket, and what they concentrate on is, well, what about the cables that are supplying the supply device? They're going to be live. My Lord, two submissions in that respect. First of all, those are not the cables which the patentee is calling out in paragraph 10. The cables that the patentee is calling out in paragraph 10 are the cables between the supply device and the socket. And furthermore, my Lord, plainly, the patentee does not regard the cables that supply the supply device as a source of danger, not least because what one sees in figure 1. Figure 1 was the first figure we looked at, which is the side view of the seat. And what my learned friends are doing is pointing at cable 28 and 29, which are carrying high voltage. And they're saying, well, look, here's a source of danger. Well, my Lord, figure 1, you see this particular source of danger runs along the floor, right underneath the passenger's feet. That's not the source of danger that the patentee is talking about.
So, Mr. Ackland, is your point that figure 1 isn't an example of what is claimed according to the construction the judge has arrived at?
No.
Is that an example of remote supply device or not?
That is the judge regards what is shown in figure 1 as an example of his construction of remoteness.
Right.
Yep. Figure 1 is consistent with my construction of remoteness. It just so happens that the supply device has been moved all the way underneath the seat. It's separate. And because my construction of remote is it imposes a minimum requirement of separateness. But provided they are separate, the claim is blind to how far away they need to be. My Lord, two other points that my learned friends make. I won't go over Quintel again or the German court decisions. As far as Mr. Borowski's evidence is concerned, what my learned friends rely upon is evidence that it was obvious to put components which control the supply voltage under the seat to protect passengers from the risk of shocks. That was his evidence. But we've seen when the judge deals with the Aring specification that he rejects that as an approach. He finds, and it's the only finding that he makes in relation to putting control boxes in any particular location. He says it was self-evident that those boxes would go under the seat. But that was not as a matter of safety, that was a matter of cabin design and convenience. And then the third point that my learned friends make is that the drenching problem is addressed by both parties' constructions, so it doesn't actually assist. Of course, that's not quite right. Judges rejected my construction, even though it would assist with drenching. That takes me to insufficiency, which I can deal with very briefly. But it follows very much from the submissions which I've been making to your lordships as to the judge's construction. If distance between the supply device and the passenger doesn't achieve anything, and for the reasons that I've indicated to your lordships already, it doesn't, then the idea of a minimum distance is utterly meaningless. The skilled person has no objective criteria for assessing whether he or she is inside or outside the claim. And the absurdity, forgive me, that's putting it in a disrespectful way. The difficulty with the judge's construction is revealed by Lufthansa's skeleton argument in the clearest terms. If one takes the core bundle B, tab 6, page 66, internal page 13, paragraph 57, where my learned friends are addressing the sufficiency submission. And they say in the third line of paragraph 57, the concept is entirely clear. The supply device should be kept away from a seated passenger such that the cables to the passenger socket are only live when it is in use. Now, the cables to the passenger socket are only going to become live when it's in use, and whether they are live or not is not influenced, not capable of being influenced by how long they are. That reveals precisely the problem with the judge's construction. So, can I tell you where I've got to so far? I've done, I hope, construction of the two issues and my solutions on sufficiency. Can I then turn to Neunschwander? And as your lordships know, I need permission to rely on Neunschwander for the purposes of anticipation. And the issue here, in respect of which I seek not only permission to appeal, but also a finding in my favour on that appeal, relates to paragraph 147 of the judgment. And in paragraph 147, the judge gives an account of there being what he says considerable room for argument as to what Neunschwander did disclose. And we're going to come back and look at that reasoning in a moment. But in 148, he says, if Neunschwander did intend the power supply to be separate from the socket, it did not contain any clear and unmistakable direction in that respect. So there is the judge finding that on my construction of remoteness, that is to say separation, Neunschwander does not contain a clear and unambiguous disclosure of that feature. And my submission to your lordships is that in so finding, the judge failed to account for that which is explicitly disclosed in Neunschwander. And given that that is what my end point is, could I approach Neunschwander in this way, if I may? I'd like to start by looking rather, as we did in the case of the patent in suit, albeit even more briefly, with the two specific embodiments which are in Neunschwander. Then show you three particular passages in the text of Neunschwander. And having done that, I'll turn to the judgment and make my submissions as why, in my respectful submission, he went wrong. So could we take Neunschwander, which is in Supplementary Bundle 1, Tab 2. And Neunschwander discloses two specific embodiments. They both utilise what is called a light barrier, which forms part of the means by which the supply of mains voltage to the socket is controlled. And if your lordships please turn to page 13, I think it's Electronic 16. Right, it's the first. Do you have any page numbers on your document?
I do.
You do?
No worries.
Do you have a page 13?
Yes.
Is page 13 the figures?
Yeah.
Splendid, right. So page 13.
Do you say 13, 1-3?
1-3, yeah.
Not sure I've got 1-3.
Right.
Tab 2.
Yes, no, I've got the specification. Mine goes up to 12.
Does this, what number does your lordship's Neunschwander start at?
Mine starts at 12.
Mine does too.
Yes. Oh, I'm sorry. You're talking about the bundle number at the bottom.
Yes, I am.
Yes, I'm sorry. I thought you were talking about the numbers of the internal specification. Yes, mine goes up to 20.
Right. Okay. Yes. Okay. Well, I'll use the bundle page number. So page 13 is the first set of figures, and figures 1 to 3 on this page show the first embodiment in Neunschwander, and the socket is viewed from above in figure 1A and to the side in figure 1B. So in figure 1B, the base plate of the socket is labelled 10, and the cover of the socket is labelled 151 in the form of dotted lines. And you can see, I hope, the pin of a plug coming in from the right through an aperture in the cover. Now, in this embodiment, the light barrier is in the form of a longitudinal bridge, which is labelled 33. You can see that in figure 1A. Through the middle of which is a light conducting channel. The light conducting channel is the hatched lines labelled 43. And on either side of the bridge are the ends of what are called optical conductors, labelled 41 and 42. And when the bridge is in the resting position, as shown here, the light channel 43 is not aligned with the ends of those two optical conductors. But when the plug is pushed into the socket, that is to say into the page in this orientation, the pins of the plug lift up the barrier, creating an uninterrupted light path between 41 and 42. And in figure 2, the socket is labelled 45. The optical conductors, the ends of which are 41 and 42, in figure 1a, are labelled 52 and 53. And they connect to an amplifier circuit, 54, which itself is connected to a relay, 51, and the relay operates to switch the mains voltage on and off into the socket. And just pausing there, if you look at the, in figure 2, if you look at the high voltage lines 46 and 48, which run between the socket and the relay driven switch, you can see a discontinuity in the form of a section of dotted lines. And Mr. Borowski explained, and there's no challenge to this, that the dotted line indicates distance between the socket and the relay-driven switch to the right. Now, looking at the conductors, 52 and 53, there is no equivalent discontinuity in lines 52 and 53. They are themselves depicted in the form of dashed lines, as is conventionally the case with optical conductors. And then in figure 3 is a block diagram of an amplifier circuit. You can see the optical conductors 52 and 53 on the left-hand side. 56 in figure 3 is a light source, for example, a light-emitting diode. 58 is a photoelectric element. And when 58 is illuminated, the relay is closed and that switches on the main voltage. Now, figures 1 to 3 are all part and parcel of the first embodiment. The way in which the components work together is described in the text between columns 7, 935 and 8, 926. So that's the first embodiment. The second embodiment is depicted on the next page, figure 5. And this shows the socket side on. Base plate is again labelled 10. Is it? No, it's not. The base plate is labelled 70. Yes, sorry, the base plate is labelled 70 in figure 5. Cover housing is labelled 75. And again, it includes what are called optical conductors. In this embodiment, there are 3 of them, labelled 94, 89, and 96, passing through the base plate. And the central conductor, 89, is attached to a double prism. And that double prism allows for 2 light paths, one on the left between the prism and the end of the conductor 94, the end being labelled 92, and the other light path is on the right between the prism and the end of conductor 96, that end being labelled 93. And Neuschwander explains that the arrangement in figure 5, this one, can be used with the circuitry shown in figures 2 and 3, albeit with suitable modifications. That is column 9, lines 37 to 55. Now this embodiment, figure 5, is described as having 2 barrier portions. And that's a reference to the 2 light paths. So in the resting position, both light paths are uninterrupted. The relay is energized, the relay to which the conductors ultimately are feeding. The relay is energized only when both barriers are interrupted. Now those are the 2 embodiments. I want to draw your attention, if I may, to 3 sections of the text in Neuschwander. The first of those is in the summary of the invention section. And if I could ask you to pick that up on page 16, 116. in column 3, line 29. And that is where the patentee begins to explain the nature of the light barrier means and the light barrier system in general. And he says in that paragraph between 29 and 38 that the barrier means may be free of any movable mechanical elements. Alternatively, the light barrier may include an elongated solid element that comprises the light transmitting path and is capable of move between a non-transmitting position and a transmitting position, e.g. a line between a light emitter and a receptor or extensions thereof, e.g. in the form of solid optical conductors, as explained in more detail below. There's then a paragraph which explains light barrier systems, that they are known already. They consist of a light source or emitter, a light sensor or a receptor, and a predetermined light path between the two, which includes or consists of the actual barrier. 57 is the first of two significant paragraphs, because in the paragraph that starts at line 57 and runs to line 65, the patentee, Neunschwander, is explaining that where the barrier portion constitutes substantially the entire optical path, the light emitter and the receptor are positioned at opposite ends of the barrier, in which case they are both arranged within the receptacle. And the next paragraph provides an alternative arrangement. Alternatively, the emitter and or the receptor may be arranged at a distance from the respective opposite ends of the barrier portion. In that case, the predetermined optical path of the light barrier means of the safety receptacle, according to the invention, will include a generally solid optical conductor, preferably an optical fibre made of inorganic or organic transparent substance, bundle of such fibres to connect the emitter and or receptor with the respective opposite ends of the barrier portion. So those two paragraphs are disclosing two alternative arrangements. The next second piece of text I wish to show you, my lords, concerns the first embodiment. And if you turn to page 17, and if I can pick it up in column 6 on the right-hand side, at line 50, the operation of an inventive safety receptacle or safety contact system will be apparent from figures 2 and 3, where the receptacle 45 shown diagrammatically includes one connector end. It's connected by lead 46 directly with a neutral wire. If you could pick it up, please, at line 58. Two optical conductors, 52, 53, the ends 41, 42 of which have been described above in connection with figures 1A and 1B, extend from receptacle 45 to an electronic amplifier circuit 54. And if your lordships just wish to remind yourselves of which bit of figure 2 that text is talking about, it was page 13. And the reference to two optical conductors 52 and 53 extending from receptacle 45 to an electronic amplifier circuit 54 is referring to the optical conductors 52 and 53, which one sees in figure 2, extending from the receptacle to the amplifier 54. And then the final piece of text to refer your lordships to, if I may, concerns the second embodiment. if your lordships go to page 19, column 9, at line 16, base plate 70, so this is a description of, this is a reference to figure 5. Base plate 70 further includes a central passage 86 and 2 off-centre passages 87, 88 for receiving optical conductors 89, 94 and 96. So that is it's simply explaining text what one sees actually in an event in figure 5, which is the conductors are passing through the base plate. So, in other words, both embodiments utilise optical conductors. They are therefore both examples of the configuration that is described on page 16 in the paragraph bridging columns 3 and 4. That is to say, an alternative to where the emitter and the receptor are arranged within the socket. If you could keep Neuschwander open and then turn to the judgment. The judge's account of what Neuschwander discloses starts at paragraph 112, which is at page 107. And it runs through to paragraph 142. And can I pick up, first of all, the judge's account of the disclosure at 121 of the judgment. And the judge refers in paragraph 121 to the first bit of text that we looked at. It says the light barrier and the associated optical electronic circuitry were discussed in more detail in column 3, lines 29 to 56. If you have Neuschwander still open, you'll see that text is certainly part of the first section that we looked at earlier. And he says in the second sentence of 121, specifically there is a light source emitter, a light sensor receptor with a predetermined optical path between the emitter and the receptor. Gives the line references. The optical path includes a light gate or barrier, vice versa. The electric signal was amplified and used to operate the relay to make or break the connection with the main supply. What the judge is describing there is what the patentee says is known about light barrier systems in general in the paragraph that starts at line 39. Now, the judge then says at paragraph 122, Neuschwander made clear in the remainder of column 3 and in column 4 that the precise configuration of the optical circuit and the orientation of the emitters and receptors was not important. He refers to column 4, lines 18 to 24. Nor was the precise design of the light barrier. Refers to column 3, lines 29 to 31. Might be of a physical structure made up of a bar. Refers to column 4, lines 36 to 38. Or a plurality of barrier portions, column 4, lines 8 to 10. Now, in so doing, he does, amongst other things, refer to the paragraph in which solid optical conductors are first introduced, that is column 3, lines 29 to 37. But he doesn't refer to what is said, he refers to the first 3 lines of that paragraph. He doesn't make any reference to the receptors or extensions being in the form of solid optical conductors. But critical in my respectful submission is the judge, although he is introducing in paragraph 122 what he says the remainder of column 3 and column 4, he makes no reference to the two alternative configurations which are described in the remainder of paragraph 3, going over to the top of paragraph 4. Next, what the judge says about the second, does not say about the second piece of text that I referred your lordships to, paragraph 131. Judge says figures 1A and 1B show the mechanical parts of the safety receptacle. Figures 2 and 3 and column 6, lines 50 to column 7, lines 34 explain the optical and electrical circuitry. So the judge is looking at both the figure and the accompanying text. And the passage to which he refers includes, when I say the passage to which he refers, the passage that is included within column 6, line 50 to column 7, line 34, includes the passage to which I showed your lordships in column 6, between lines 58 and 61, namely the reference to two optical conductors extending from receptacle 45 to the amplifier circuit 54. But there's no mention of that in any of the judge's description in paragraphs 132 to 135. And then finally, 136, the judge is here giving an account of the second embodiment. He refers to figure 5 and also the accompanying text. But there's no reference in the judge's account of the optical conductors being described in the text as passing through the base plate. Can we then turn on in the judgment? And turn on to 144. So we are here dealing with clear and unambiguous disclosure. The judge explains there's a disagreement between the parties. 145, he gives an account of the submissions made by Lufthansa. 146, he gives an account of the submissions made by Astronics. And 147 is the judge's analysis of the final position. And he concludes, as we saw before, that there is, on his view, no clear and unmistakable disclosure of a separate configuration. And if we look at 147, and also, there are two pieces of reasoning in my respectful submission. First of all, he says that figure 2 suggested a degree of separation. But he says it's not clear that figure 2 was intended to show the location of components as distinct from being a schematic diagram. And as if one reads the end of that paragraph, I think that's what he means when he says that figure 2 it contains the possibility of separation, but no more than that. And then in the middle of the paragraph, he says that he's not wholly persuaded that the reference to at a distance, so that's in the paragraph that bridges columns 3 and 4, indicates that the receiver and emitter are outside the socket. But even if they were, that wouldn't add anything to the possibility of separation in figure 2. What I'm going to now make my submissions is what my criticisms are of that part of the judgment. Would you like, it'll take me a little longer than 3 minutes.
How long is it? How much longer than a little longer?
It'll probably take me
Do you think it's
5 minutes. So you may then hold me to it,
which do you think would be better? Stop now?
I think it would be better to stop now.
Then we will. So we'll start again at 2 o'clock.
Court rise. Just turn the live stream off, so we've got 90 seconds.